So you got Frederick Allen, right? So Frederick Allen, he owns the videotape. He's the one that took the video. You have Blackbeard, who's this pirate, this terrible person, went around plundering and raping and robbing and just doing all this. He sinks, his boat sinks off the coast of North Carolina. So by law, something, federal, state, I don't know. But apparently one of the corporations that want to bring the ship up had made a deal with North Carolina because North Carolina technically owned the pirate ship of Blackbeard that sunk. I think it was the Queen Anne's Revenge. So North Carolina owned the Queen Anne's Revenge. Then this corporation made them a deal to raise them. They signed off on the deal. The corporation contracted, so it's a contract, the contractor of a contractor, right? So third hand, Frederick Allen is going to be contracted to videotape the entire thing. So to, raise it and all of it, right? To deep dive, scuba dive, then they bring up the anchor, and so he videotaped all of that. In North Carolina, they didn't pay him for his work. North Carolina paid him $15,000 for one thing that they stole from him, but they pirated. They plundered Frederick Allen's intellectual copywritten material. It was on videotape. It was his videotape. He took it. He owned it. And because of this 2020 Allen v. Cooper decision, Frederick Allen v. Cooper, I'm not sure who, Mr. Cooper, so maybe the insurance company. So the holding of the 2020 Allen v. Cooper Supreme Court case just recently decided the states in America cannot be sued in federal courts for copyright infringement because Congress did not validly abrogate sovereign immunity when they wrote the 1990 Copyright Remedy Clarification Act. So they're going to, throw that act, that law, 1990, or Copyright Remedy Clarification Act, into the trash. They're going to say it's unconstitutional, it's too broad, you can't even use it, get that shit out of here. If they would have said something about sovereign immunity, but they didn't even mention sovereign immunity. As if sovereign immunity isn't repugnant to any freedom-loving person. As if sovereign immunity isn't repugnant to the U.S. Constitution. As if sovereign immunity isn't repugnant to the right of revolution. So, the American Revolution, the entire federalist system of government, sovereign immunity. You don't know sovereign immunity. That's for kings and queens. That archaic, old-ass principle, that's not in the Constitution. The Constitution itself didn't even give them sovereign immunity. So the 2020 Allen v. Cooper decision, what a dumb Dred Scott decision, what a Plessy versus Ferguson decision. This is a Chaplinsky kind of decision. 2020 Allen v. Cooper. It's about as dumb as the Hans decision. Am I right? That damn Hans decision. So, Nautilus Productions is a corporation. They now cannot, owned by Frederick Allen, he cannot pursue its copyright protection infringement lawsuit against North Carolina in federal court. Why? Because North Carolina, the holding is North Carolina can pirate your intellectual property, but you can't pirate North Carolina's intellectual property. They go after people if they, steal their stuff, but they're allowed to steal your stuff. They posted it up on YouTube without his permission, paid $15,000 for one of his things, but I guess apparently now any and all of Frederick Allen's video is just up for grabs. Anybody or is it just the government of North Carolina? Is that the only person that's allowed to pirate Frederick Allen's stuff? And they use the concept of sovereign immunity. And sovereign immunity is an absolute power. So kings and queens can annul themselves of any and all accountability for their decisions. The king can do no wrong. A Latin phrase, rex non potest pecare, whatever. It's fucking bullshit. The king and queen can do wrong since they do have power. Article 88 of the Belgium Constitution says that the king's person is inviolable, but his ministers can be held to account. So you can't go after the king or the queen, rex non potest pecare. The king can do no wrong, bullshit. The emperor is wearing no clothes. And sovereignty only applies, this whole idea of, sovereign immunity, That only applies to royalist governments, you know, the constitutional monarchies, not our Constitution. We don't even, that's not even in the Constitution. Nowhere do you see sovereign immunity in the U.S. Constitution. In a democracy, we believe in a rule of law, a pinnacle, a linchpin, a foundational stone, a pillar, an absolute essential of democracy is a rule of law, which says that nobody is above the law. Not the state or the state actors or the rich or the poor. Nobody is allowed to murder. Nobody is allowed to steal. Nobody is allowed to rape. So this is the rule of law. Just because you're a part of government doesn't mean you're allowed to break the laws. You're not sovereignly immune. You're not above the law. Nobody is sovereign immune. Maybe if it's like, you know, some sort of court case, they can like give immunity for one person for their testimony or some shit. But qualified immunity, is that where this comes from? Sovereign immunity? Qualified immunity takes a piece of the sovereign immunity. This whole idea of sovereign immunity is just bullshit. So the SCOTUS decision against Frederick Allen in the 2020 Allen v. Cooper case is a dumb, backwards ass. It was unanimous. They were all unanimous in, you know, being against Allen, holding up the 11th Amendment supposed, assumed background principle of sovereign immunity. The 11th Amendment doesn't mention sovereign immunity, but the 11th Amendment would be the biggest hurdle for anybody that takes the position that I'm taking right now. So Colorado, Utah, Hawaii, they can all steal Disney's copyrighted material. They can steal corporations' copyrighted material, individuals, Americans, in any state. So not just Colorado, Utah, and Hawaii, but Idaho, Montana, Delaware, New Hampshire. So right off the top, okay, so why is this Allen v. Cooper 2020 case just really stupid? Why is it so dumb? So Justice Clarence Thomas, they all, you know, is unanimous, they all concurred. But Clarence Thomas, he mentions, you know, I don't even know if copyrights are property to begin with. And he puts it in the context of the 14th Amendment. So due process, you can't be deprived of life or property, I guess, with the 14th Amendment. So is intellectual property, copyrights, and patent, is that property under the 14th Amendment? So Clarence Thomas is like, I don't even know if copyrights are even property, but fuck it, you know. And then Justice Breyer, he says this, in, you know, I don't know, in his opinion, or, yeah, probably his opinion, right? So states who pirate copyrighted material should pay for which they plundered. So Justice Breyer imagines a day. Just imagine when states, governments, the governments of the American states who pirate copyrighted material from individuals or corporations actually pay for that which they stole, for that which they plundered. But ultimately, Breyer says the precedent points in one direction, stare decisis, his hands are tied, so he went along with the unanimous Allen v. Cooper decision. This dumb Shink, Dred Scott, Chaplinsky, Plessy versus Ferguson decision. So poor Disney Corporation, they're just going to get their millions and millions of dollars of intellectual property straight up jacked by state governments now. Probably federal governments too, right? They all probably just cloak their crimes with sovereign immunity. This is archaic English common law. Fuck sovereign immunity. Sovereign immunity is bullshit. Is this why we invaded the Nazis at the beaches in Normandy? Huh? Is this why D-Day, is this why we stormed up San Juan Hill? Is this why we listened to the shot heard around the world? Is this why we invaded Korea and Vietnam? Is this why we fragged our officers in the jungles of Vietnam? So Elena Kagan, 2020 SCOTUS decision, she wrote the damn thing, so she's going to say something about something, okay? She's going on Florida Prepaid. So she's like, Florida Prepaid already wrote this thing for her. She basically, her hands were tied too. Here's her, you know, words. Florida Prepaid acknowledged that Congress's goal of providing uniform remedies in infringement cases was a proper Article I concern, but held that Seminole Tribe precluded Congress from using its Article I powers to circumvent the limits sovereign immunity places upon federal jurisdiction. And for the same reason, Article I cannot support the CRCA. some other congressional law that they're going to overturn. So Elena Kagan goes ahead and what? Florida Prepaid is a case. Seminole Tribe is a case. And so these have to, okay, so the Seminole Tribe versus Florida, this is a 1999 Supreme Court case where the Seminole Tribe of Florida got fucked hardcore because they followed the federal Congress's law that said something about the good faith negotiations. Congress under Papa Bush passed a law. I don't know if Papa Bush, but some president passed a law saying they got to get together and have good faith negotiations. So the Seminole Tribe of Florida did that. They did what the Congress, the federal government had dictated, and then the federal government, the court, Supreme Court, is going to overturn everything that the Seminole Tribe of Florida did. So I think it was a split decision. I'm not for sure, but the main thing about the Seminole Tribe of 1999 SCOTUS decision to remember is just that the Seminole Tribe of Florida got fucked hardcore. So how convenient, right? The Supreme Court is going to rule against the Native Americans as if the Native Americans haven't been fucked enough. So Elena Kagan, she could try reading the U.S. Constitution before she, starts writing, stuff, before she starts spouting off at the mouth. So specifically, Elena Kagan can read the patent clause of the U.S. Constitution. That's Article 1, Section 8, Clause 8. Again, Article 1, Section 8, Clause 8 is the patent clause, which is the constitutional part of the Constitution that says that they have the power to patent and pass laws about patent. And so when Congress passes a law about patent, they have, specifically constitutional authority to do so. Also, Elena Kagan could check out the powers of the Judicial Branch Clause. That's Article 3, Section 2. She works for the Judicial Branch, so Elena Kagan could try to, bone up on the powers that she herself has. Article 3, Section 2. Now, this is going to be brought to light with the Chisholm v. Georgia decision. This is another important Supreme Court decision, 1793 John J. Court 4-1 decision. First Supreme Court decision of major impact decided February 18th, 1793. So Chisholm v. Georgia, the holding of the Chisholm decision, Chisholm v. Georgia 1793, is that Article 3, Section 2's grant of federal jurisdiction over suits between a state and citizens of another state abrogated the state's sovereign immunity and granted federal courts affirmative power to hear disputes between citizens of all states and all the state governments themselves in any combination. So the federal courts could hear suits between citizens of states and another state, a state and citizens. So Article 3, Section 2. Here, I'll just read the damn Constitution for you, Elena Kagan. So the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority. So right there, the U.S. Constitution is the law of the land for America, so therefore anything that happens in America has to be consistent with the U.S. Constitution. Yeah, maybe that's too much federal power. Okay, so the Article 3, Section 2 carries on specific, right? They're very specific about the powers that they have. The judicial branch of the federal government shall see to all the cases affecting ambassadors, other public ministers, and consuls, and to all cases of admiralty and maritime jurisdiction. Also, it's going to be held, the federal court is going to have power over all those cases. And specifically, verbatim, quote me, Article 3, Section 2, to controversies to which the U.S. shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, and subjects. What the fuck do you think all those words mean? Between citizens of different states, between the states themselves, between the state and different citizens and the different state and citizens, every different combination covered in this clause. Foreign state citizens subjects between a state or the citizens and other foreign governments, everything is, covered under Article 3, Section 2. And it carries on, verbatim, trial of all crimes. This is the U.S. Constitution, America, so the trial of all crimes except in cases of impeachment shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Kind of makes you think a little bit about Julian Assange. So, because the crime didn't happen in the United States, then Congress gets to make, up wherever the hell he's going to be tried. It didn't happen, right? Julian Assange got information over in Europe, and then he published it, and that's somehow a crime. Even in our Constitution, I guess it doesn't, the rights don't protect him, but the enforcement goes against him. I think if you can enforce law against him, then they also get the rights. Human rights, definitely, 100%, without a doubt. And constitutional rights, I would think, they don't get American citizenship rights, but they get American freedoms as far as foreigners are concerned. So it's like, anyway, so the facts of the case make logical sense of the Chisholm v. Georgia case, because people say, oh, that was before the 11th Amendment. But this is when, everything was just, the way as it should be. February 18th, 1793, where the beer flowed like wine. Two men from South Carolina, Farquhar and Chisholm. This is the two men from South Carolina. They are trying to get money from Georgia because they helped pay for their involvement in the Revolutionary War. The state of Georgia owed Chisholm some money since Chisholm was the executor of Farquhar's estate. So Farquhar's dead. So it's just Chisholm, right? It's Chisholm v. Georgia. So Chisholm had worked or had owed, Georgia. Chisholm did some work for Georgia in the Revolutionary War, provided some guns, some weapons, wagons, soldiers' uniforms, food, what the fuck ever. Chisholm gave Georgia supplies, money, whatever, and he was owed some money. And Georgia said, we're not going to pay you. Nah, we're not going to pony up, you pony soldier boy. Look here, fat. Okay, look here, fat. Look here, you dog-faced, lion-ass pony soldier boy. You pony soldier boy. What a weird... So look here, fat. Okay, look here, smart guy. Look here, fat. So Georgia says, we're not going to pay. Georgia doesn't even show up to court. But Chisholm says, nah, this is some bullshit. You owe me money. I'm taking you to federal court. And that's the way it ought to be. This citizen from South Carolina says that Georgia owed him money. How else could he force Georgia to pay him? Georgia says, fuck you, we ain't going to pay you shit. So unless South Carolina invades Georgia, what else can Chisholm do? The federal court is missing a big, huge opportunity to be a non-biased third party, mediator between citizens and states. And so Georgia owed some money to citizens of South Carolina, but Georgia wouldn't pay up. So what is a South Carolinian citizen supposed to do? Rely on Georgia and their courts? Yeah, Georgia will just side with them, right? So they're biased. Rely on the South Carolinian courts, okay. That might go good for Chisholm, but would Georgia abide by a South, Carolinian, even a Supreme Court decision? If not, who would enforce it? South Carolina would have to invade Georgia in order to force them to pay up. And so is this issue big enough for the government of South Carolina to invade Georgia? No, but it's one of many transgressions. So yeah, Georgia is just a bunch of, meth heads trying to keep the rent accounts of TV by ducking process servers with their subpoenas. Georgia doesn't even show up to court, pretend like who? Us? We don't know. We didn't pay. No, we didn't. What? Revolutionary War? We never gave Farquhar and Chisholm any money. No, we never made that. What revolution? I don't under. The Chisholm decision was a good decision because it's, right. Justice was upheld, and it says that, citizens of other states could sue other states. You could sue your own state. You could sue other states. You're an American. Hell, you have a right to sue. That's a human inherent right. to sue in a state and federal court, that is obviously a human God-given right and proper and fair and true right that every American has. Of course, we're allowed to sue our own states and other states. We're allowed to sue anybody and everybody for any goddamn thing we want to. That's our right as Americans, the right to sue. Oh my God. I mean, take away the right to guns and right to free speech, but take away the right to sue, American economy would drop. And really, just the patent and copyright and intellectual property clause, Article 1, Section 8, Clause 8. Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Surely citizens can sue other states with the patent clause, with the patent law. If federal courts can't even protect constitutional law, the foundation law for all the rest of the law, I mean, perhaps federal courts should just get out of the business of judging altogether. We have a patent clause, and then the power of the judicial branch specifically says they're there to mitigate between citizens of states and other states and this and foreign governments and here and there. Everywhere, the judicial, branch has power to be the third-party, non-biased judger in that outfit for any and every, goddamn controversy that could arise. So the patent clause backs the 1990 Copyright Remedy Clarification Act. The U.S. Constitution backs the 1999 upholding the right of this law to be. So this is 1990, Papa Bush, right? CIA Director George H.W. 1990, old Copperfield. So Copperfield, 1990. So that's like the most recent, one that I know about, 1990, but it's overruled. So what copyright laws even being, what's the copyright law of the land? So just imagine that. You write thousands of pages of a law, 1990 Copyright Remedy Clarification Act. Supreme Court just overthrows the damn thing and leaves nothing in its place. Marbury v. Madison, y'all got judicial review, right? Just unconstitutional. That's unconstitutional. Everything's unconstitutional. So it just added Title 17 provisions, and it stated clearly that states shall not be immune under the 11th Amendment of the Constitution or any other doctrine of sovereign immunity from suit in federal court for a violation of the exclusive rights of a copyright owner. Well, shit, that's pretty clear, cut and dry right there. You can't use the 11th Amendment and sovereign immunity to sit there and steal, poor Frederick Allen. Poor Frederick Allen went down there. He's got a hook for a hand. So Frederick Allen, that's after all this happened, but still, he suffered and he's had a hard life, but at one moment in time, he was a part of history. Blackbeard's pirate ship was being raised. He's underwater videotaping it, and he's videotaping this and that, getting all these images and stills and shots and photos. So much intellectual property. But North Carolina wants to rob Frederick Allen, and the Supreme Court says it's okay for state governments to rob copywritten, patented, intellectual property rights. They could trample on these rights of individuals and corporations. Everybody. So everybody is Frederick Allen. Nobody has because of the 11th Amendment, because sovereign immunity. You haven't read the 11th Amendment correctly, Elena Kagan. So 2 points. The Constitution says that the federal government can use the courts to resolve disputes between the states and the citizens in any and every combination, Article 3, Section 2, and in the Constitution, there's a patent clause, Article 1, Section 8, Clause 8, which upholds the patent law of 1990. There's been a bunch of patent laws, 1790, 5 or 6 that I know about. So for 200, 300 years, the precedent has been the federal government can pass patent laws, and then they could fight for their copyrighted material in federal courts. Another sketchy thing, North Carolina is going to cover their asses retroactively. They passed Blackbeard's Law. This is a state law passed retroactively to cover their ass to steal Frederick Allen's Blackbeard's images and videos, so they could steal the intellectual property from the citizens. And if he's from North Carolina, then I don't see where the 11th Amendment, where he goes wrong. Let's get into the 11th Amendment, okay? So if Frederick Allen is from North Carolina, he absolutely has the right to sue North Carolina, even per the 11th Amendment, because they specifically exclude a citizen. They ban several lawsuits. They ban foreigners from suing any American state. So no foreigners can sue any American states. I'm okay with that. They also ban every American citizen from suing any of the other states. And then they ended it off with just that. So they specifically omitted, they specifically excluded the right for a citizen to sue our own state. That says, you know, that's American right as apple pie. That's so goddamn American, the right to sue our own. Of course we could sue our own state. But North Carolina, just to show that they're hypocrites, they, you know, pursue all these cases to steal intellectual, you know, they don't want anybody stealing intellectual property from them, but they, you know, are going to be hypocrites and say that they could steal intellectual property from us. Pennsylvania and Tennessee actually never ratified the 11th Amendment, so that's a special privilege that the citizens of Tennessee and Pennsylvania can use. So, yeah, okay, the 11th Amendment, federal government, they're supreme and shit, but Tennessee and Pennsylvania, they didn't ratify the 11th Amendment. The 11th Amendment should never have been ratified to begin with. I am opposed. I hate this stupid amendment, but let's read it and see what the fuck we can, you know, do with it. The 11th Amendment reads, the judicial power of the U.S. shall not be construed to extend to any suit in law or equity. Therefore, no lawsuits, criminal law or civil law, suing for money or suing to throw people in prison, or, you know, the judicial power of the U.S. shall not be construed to extend to any suit in law or equity, criminal or civil, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. So the judicial power of the U.S., the federal government's judicial branch, does not have the power to bring up any criminal or civil suits against any of the United States that are brought up by citizens of another state, or by citizens or subjects of any foreign state. So therefore, citizens of Germany cannot sue me. I am a citizen. I'm an American citizen in the state of Colorado. So that means I can sue Colorado, but I cannot sue Tennessee. And nobody in Germany can sue anybody. The Tennessee nor Colorado can be sued by the people in Germany. So this you know, bans citizens from other states and countries from suing your state, but it specifically excludes that you can sue your own state. As a strict constructionalist, the amendment as written allows for any citizen of Colorado to sue the state of Colorado in a federal court for any reason. It does not ban a citizen from suing their own state. So if Frederick Allen is a citizen of North Carolina, he absolutely 100% has a right to sue North Carolina. If the 11th Amendment meant to ban a citizen from suing their own state in federal court, then it would have said so. But it explicitly, literally excludes it. Hell, isn't a citizen suing their own state a God-given natural human right? So Pennsylvania and Tennessee never ratified the 11th Amendment. The citizens of Pennsylvania and Tennessee can say the 11th Amendment don't apply to them. A little bit of legal history. It's got 1 minute. Some legal history is you had all these copyright laws that were passed. The 11th Amendment is going to be passed in 1795. The first Copyright Act was 1790, 172, 200 years ago. There was no sovereign immunity back in 1790, none back in all these Copyright Acts. 1831, 1870, no sovereign immunity for those Copyright Acts. The Trademark Act of 1946, the Lanham Act, that there was no, and then the 1990 Copyright Act. Then now all of a sudden there's, sovereign immunity. Now, since for 200 years, sovereign immunity wasn't, a factor, but now in the last 20 years it's become a factor. Frederick Allen owns his own images that he videotaped. It was his images. He owns them, and North Carolina owes Frederick Allen some money still. So North Carolina justice did not happen. North Carolina owes Frederick Allen money, and they're going to get away with not paying him for stealing his intellectual property. So there's been lots of copyright acts passed: 1790, 1831, 1870, 1946, the Lanham Act, and 1990.